Hello, my name is Christopher Badger, barrister at Six Pump Court, and welcome to the 5th edition of our Environment Law News Bulletin, brought to you in association with LexisNexis. In this bulletin, we look at the new consultation on the proposed independent environmental watchdog, the Public Accounts Committee's damning assessment of DEFRA's Brexit preparations, and new EU infringement proceedings against the UK for air quality. DEFRA has launched a 12-week consultation in which it states that a new Environmental Principles and Governance Bill will create a new, world-leading, independent environmental watchdog to hold government to account on the UK's environmental ambitions and obligations once the UK has left the EU. Issues on which DEFRA is consulting include: should the new independent body have the power to provide independent scrutiny and advice of implementation of environmental legislation and government policy? To what extent should it be able to handle complaints, conduct investigations, and require the provision of information? To what extent should the new body be able to supervise the government delivery of environmental law and take formal compliance action? Any potential powers to take enforcement action against the government would be limited to where a legal obligation exists. Critically, it isn't suggested that the new body will be able to take the government to court. Should the new watchdog's remit extend to public bodies outside central government departments? If so, this will presumably require additional resources. Otherwise, the government risks diluting the body's focus on the most significant national or strategic issues. To what extent should the remit include oversight of international environmental agreements? It is also intended to create a new statutory statement of the environmental principles that will guide the UK, drawing on the current international and UK environmental principles. Two options are canvassed, either as part of primary legislation or as a policy statement. The proposals in the consultation have already been the subject of scathing criticism in the House of Lords, in particular from Lord Krebs, who described them as simply too weak, far weaker than the Commission's current powers. This directly led to the government's 15th defeat on the withdrawal bill, which specifically seeks to establish a legislative duty on public authorities to apply EU environmental principles, such as the precautionary principle, as well as a list of functions currently exercised by EU bodies that are required to be retained or replicated in UK law, so as to prevent the diminution of environmental protection. On the 4th of May, the House of Commons Public Accounts Committee published a report roundly criticising DEFRA's preparations for Brexit. The committee took evidence in preparing its report on the 7th of March. The committee stated that DEFRA's preparations are being hampered by the pervasive uncertainty about the UK's future relationship with the EU. The corollary being that DEFRA is having to work out options for deal, no deal, or transition scenarios, and that the department's burden during the Brexit process is larger than most, given that the bulk of its areas of responsibility are framed by EU legislation. To put DEFRA's burden in perspective, it is, according to the committee, responsible for 43 of the 300-plus Brexit-related work streams in government, with just over half having an IT component, and some requiring the establishment of new regulatory bodies. DEFRA is being asked to deliver all of this, the report goes on to concede, against a backdrop of major new legislation on agriculture and fisheries, and ongoing business and efficiency savings of £138 million in 2018 to 2019. If you weren't filled with sympathy for the civil servants at DEFRA before, you may, indeed perhaps should, be now. Some of the committee's conclusions and recommendations are stark. Planning for deal, no deal and transition scenarios is the fault of uncertainty. DEFRA must, by July 2018, publish on its website information and timelines setting out how and when they will be able to provide more explicit guidance to businesses and stakeholders on preparing for Brexit. The Treasury must improve its processes for approving Brexit funding, so departments have certainty about funding and can plan effectively. With DEFRA estimating that 80% of its functions are in devolved areas of policy, it must, by July 2018, report to the committee on its engagement with devolved administrations. It is unrealistic to expect DEFRA to achieve its efficiency savings alongside delivering Brexit and its other work, and it should acknowledge that it cannot continue to do everything it is currently doing, and should write to the committee by the end of June 2018 with proposals for prioritisation. Perhaps most worryingly, there are substantial risks, including disruption to the agri-food and chemical industries, if DEFRA's IT systems are not ready. The committee noted the potential for disruption and requested an update, again by the end of June 2018, on the progress of the new IT systems. Rather alarmingly, there is talk in the report of manual processes if IT systems are simply not ready in time. On the 17th of May, the European Commission confirmed that it has referred the UK, together with France and Germany, to the European Court of Justice for failure to respect limit values for nitrogen dioxide and failing to take appropriate measures to keep exceedance periods as short as possible. The UK has breached the legal limit for nitrogen dioxide in a number of regions since the legislation came into force in 2010. Plans to bring the UK into line with its obligations have been overturned numerous times in the courts, most recently in January of this year, in a series of cases taken by Client Earth. The announcement came just days before the government released its draft Clean Air Strategy on the 22nd of May, to be backed up through new primary legislation, which will focus on giving more powers to local authorities, which could include powers to implement measures such as clean air zones. However, no reference is made to how local authorities would fund such proposals. Perhaps more critically, especially in light of the EU's legal action, the plans do not tackle the issue of road transport and traffic in any detail, still the main source of air pollution in towns and cities, and accounting for nearly half of all nitrogen dioxide emissions in the UK. This has led to Green MEP Keith Taylor describing the plan as dangerously inadequate, and major environmental NGOs raising concerns as to how the government intends to take the most polluting vehicles out of the most polluted areas in the country. Thank you for tuning in for this Environmental Law News Bulletin. For more information on any of these stories, please contact Six Pump Court or my colleagues at LexisNexis. Future Environment Law News Bulletins will be in the form of an audio podcast, which you will be able to hear directly on or download from the LexisNexis purpose-built blog and the Six Pump Court website.